my pretties. Hope you're all having a good day. I am on my way back after a settlement conference at the Toronto Small Claims Court. And a couple of things happened today that got me thinking, and I feel like I need to share some information with you all about this idea of keeping it pretty. So the first thing is, don't assume that the opposing counsel or opposing representative is doing something wrong. So let's say the opposing representative has said something or done something that you think is procedurally incorrect. Don't assume that it is in fact incorrect before you start accusing them of doing something wrong and being a terrible lawyer or paralegal. Actually check your facts first. That actually happened to me today, where the opposing representative made an assumption, but it was completely unfounded. So the second way that you can keep advocacy pretty is similar to the first. If opposing counsel or an opposing representative is assuming that you've done something wrong, don't just assume that they're right. Don't just believe them. This happens especially in situations where you have one representative who is a little bit more senior than the other representative. And I find it myself personally, I always like it when I am dealing with a lawyer or paralegal on the other side who has more experience than me, because for me it's sort of like an opportunity to learn and grow. You know, I sometimes go into these situations thinking, okay, this person's going to keep me on my toes and I really need to bring it, but I'm also open to how they might do things and what I can learn from their experience. And it isn't always the case that you will learn something from them. It isn't always the case that they know more than you. So it also reminds me of an instructor I once had in school. He taught us that if anybody ever says to you, you must do something, or you shall do something, or you didn't do something, or you failed in some way, your first response should not be to just accept that. Your first response should be, by what authority? In this matter, I'm representing the defendant, and the opposing representative received my defense, but she didn't like the way that I sent it to her, and so she insisted that I did something wrong and that I needed to serve her in some whole other way and incur further expense to my client to do it. And this person is technically more senior to me, but what I'm trying to tell you is, even if that may be the case, don't just assume that they know better than you. You ask yourself, by what authority must I do the thing they're saying I have to do? And that's what I did. I went to the rules and I double checked the rules and confirmed for the opposing representative that actually, according to the rules, I correctly served the defense. And once I sent that rule, there was no more dispute on the issue. Okay, so again, first way to keep things pretty, don't assume that the opposing representative is doing something wrong. Check your facts first, check your authorities first. The second way is similar. Don't assume if somebody accuses you of doing something wrong that you are in fact wrong. Double check the rules, make sure you're doing everything in accordance to the rules of the court, rules of civil procedure, tribunal rules, whatever your forum is. Double check. So the other thing that you can do to keep things pretty in your practice is to make sure that your client has evidence, that they have some kind of proof before you issue a claim. So I just spent several hours preparing for a settlement conference and attending a settlement conference as a representative for a defendant in a matter where the plaintiff did not have any supporting documents whatsoever. They didn't have any evidence at all. And their paralegal, I guess, was okay with that. I had sent several emails inquiring about documents. The plaintiff actually reached out to me directly and copied his paralegal, which isn't appropriate, but that's what he did, to see if we could settle. But I mean, how could we have a meaningful settlement without any documents? And that became one of the issues in the settlement conference today, and the judge confirmed my position on this, that the burden of proof rests on the plaintiff, right? So it's impossible to have a meaningful settlement conference or even discuss settlement when the claim itself isn't really supported yet. And on top of that, so much time has passed. It was just such a big waste of time. We ultimately had to adjourn, and more time is needed to procure those documents. Well, what I'm trying to say is it's better to take the time you need to gather the supporting documents and evidence and then issue the claim. If you are up against the limitation period and you're worried that you're not going to have enough time, you just kind of need to get it in, well, then I appreciate that. But please do make sure you hustle to get something to the other side that can open up discussions and potentially lead to a settlement. It's impossible to do it otherwise. So make sure you have evidence, you have some kind of proof before you issue the claim or shortly thereafter, and definitely that you have some kind of proof at least 14 days before the settlement conference and that you have served it to the other side. The fourth way that you can keep things pretty as a paralegal, particularly when we're dealing with litigation, right? Like, we're always dealing with some sort of dispute. The other thing you do is to be open with the opposing counsel or opposing representative. I say that because in relation to the last point, if you don't have what you need to proceed and you need more time, just ask for that time. I mean, things come up, things happen, right? And it's better that you are honest about that time that you need so that it can save everyone else time. Had the opposing representative came to me and said, you know what, we're not really ready, we don't really have all of our documents together yet, we need more time to do this, I would have said, okay, you know what, let's adjourn. And at least that's better for my client as well, instead of him missing a whole day of work and me incurring billable hours that's going to cost him. You know, we could have adjourned. And in fact, I actually reached out to them multiple times to inquire about how things were going with their documents. Do they need more time? Please let me know. That was an open invitation to say, hey, we need more time. Let's just kind of be open and honest with it. At the end of the day, like, we're all, as paralegals, just trying to do our job and to do our best job for our clients. We're not at odds with each other. You know, there's no reason why we shouldn't be cordial, which goes into my next which goes into my next way to keep it pretty. And that's be polite, be cordial. I mean, you'd think it would go without saying, but you'd be surprised. Things get really, really heated sometimes for people. It can be an emotional process, but there's no need for name calling, insulting, or kind of putting each other down. I think people watch too much TV and they see these really catty lawyers on television shows who are just cussing each other out, and we really don't need to be like that. It's just not necessary. We can be polite and respectful and professional, and remember that we are colleagues. Even if we are on the other side of the table, we are colleagues, and we have a duty to work together for the benefit of each of our clients, of course. So the other thing I want to talk about is the importance of improving and working on your legal writing skills. One of the issues that came up in today's hearing, and this is part of the reason why I'm making this video, is the fact that the claim that was issued did not actually give a lot of information. It was very vague, and it made it very difficult for us to have a meaningful settlement discussion, or just to even talk about the case at all, because the information that was filed was like nothing. There was very little to work with there. An allegation was made, but the pleadings did not specify when the conduct, we're dealing with tort, when the tortious conduct occurred, how it occurred, what the damages were. So, how do you respond to that? So I really want to encourage you to really think about your documents, think about your pleadings, think about your claims. Don't just put something out there and issue it just because. Otherwise, you risk creating a vexatious and really frivolous matter, which can actually bite your clients in the rear in the end, because they could end up being responsible to pay costs. So really put some thought behind your writing, and if you don't feel you have strong legal writing skills, then maybe have somebody look over your documents before you file them, or take a CPD course to learn what you can do to improve your writing skills. The seventh tip that I want to give you is to make sure that you actually understand the cases you are relying on. Today, I was dealing with a matter where the opposing representative mentioned in their pleadings that they intend to rely on a decision if this matter goes to trial, and that they explained why they were intending to rely on this decision. However, when I did my research, I discovered that the case that they were relying on had absolutely nothing to do with the issues that they were pleading in relation to their claim. It had to do with something completely different. And on top of that, that particular case set a precedent for a legal test to prove the particular type of liability. And based on the claim that was filed and the lack of documents, there was no way that if we went to a trial, this case that they said they were going to rely on, there's no way they'd be able to meet the legal test. And I kind of wondered whether, what were their reasons for mentioning this case? Did they actually read it? Maybe they didn't understand what they read. I also noticed that this particular case established that proof of actual damages were not necessary to find liability. However, they still had a test, and part of that test involved proving that the person, that the defendant actually committed the act and did so maliciously, and a whole bunch of other stuff. So none of that was at all provided in the claim against my client. So I thought to myself, well, why did they make a point of mentioning this case? Was it because they picked a random number, like they literally brought a claim for the maximum monetary jurisdiction, but didn't actually feel that they had to put some thought behind why that claim or why the damages were that amount? I'm not sure. Either way, the point that I'm making is this. make sure if you're going to mention a case or rely on a case in your action, make sure you really understand it. And one of the ways that you can do that is to do further research besides just reading the actual decision. Read memoranda that have been written by other lawyers or paralegals. See how other licensees have explained the case to make sure that you're understanding it the same way. So the 8th tip that I want to give you is to teach your client how to behave. And maybe that sounds kind of silly, but I think it's really important. You need to prepare your clients for what they can expect when they go to court, how this process will work, your role in that process, and how they should address the adjudicator and the opposing party or opposing counsel or opposing representative. Today, I witnessed a really good example, of a situation where the paralegal did not prepare their client. So ultimately, the client, when speaking, interrupted the judge, kind of argued with the judge somewhat. It was very unusual, but not surprising. It simply means that he was not really prepared and he didn't really understand how this process worked. It also became clear to me and to the judge that this person did not really understand how the court process works or how the rules of evidence, generally speaking, work. The fact that we are in a justice system where disclosure of evidence is really important. You can't just ambush the other side and expect that that's going to be okay. It doesn't work that way. There's due process, and it's there for a reason, especially if you're going to bring an action against somebody and put them in the hot seat, cause them to miss time in their job, cause them to lose money because they're paying for legal fees. You need to be prepared, and you need to prepare your client for the expectation that's going to be on them if they bring an action. And whether or not you're representing the plaintiff or defendant or applicant or respondent, you need to prepare your client for how they need to behave when they are before the adjudicator and in a proceeding. Tip number 9 is very much related to tip number 8. I'm just going to sit here for a minute. So it's very much related to tip number 8 in that while you do need to prepare your client for how they should behave and speak and all the things, you're not going to tell them what to say, but you want to prepare them for, I guess, the etiquette of, civil procedure. We'll call it that. Although you want to prepare them, you also need to be aligned with your client. What I mean by that is this. Before you head into a proceeding, particularly a settlement conference or a mediation, you should have already put the work in and the time in with your client to really understand their case, to really understand their situation, their feelings, their experience, their evidence, what it is that this is going to be all about. Because at the end of the day, it is you who must stand in their place and act for them. Today, I witnessed a situation where the paralegal was explaining the claim one way and kept getting interrupted by their client, the plaintiff, to say, no, that's not what happened. No, it's not like that, it's like this. And it was a big mess. And I had to, my position was simply that, I don't know how to respond to any of this because I don't know what's correct. The documents say one thing, the pleadings say one thing, the paralegal saying another thing and their client is saying something completely different. So what is the action? Does anybody know what's going on? And I'm sure that was not intended, but that's what happens when you are not aligned with your client. You need to know their case almost as well as they do. In fact, better. You need to know the most crucial aspects of their case. I often take maybe more time than I should to really sit down with my clients to understand them, to understand what has happened, how it's affected them, and then I take all that information and I decode what is actually relevant based on the rules of evidence, based on the standard of proof and the burden of proof, depending on, of course, which side you're on. It's up to you to decode what's relevant from the information they give you and to reiterate that back to them to make sure that you are on the same page and that they understand what your role is in all of this and why it is that you might lead with one particular set of facts over another, et cetera, et cetera, et cetera. Be aligned with your client. Otherwise, things can get very messy and very confusing and very frustrating for all involved. And, sometimes I guess this just you learn this through experience. But that's also why I wanted to share this with you, because sometimes you don't really stop to think about things like this until it happens to you. And it can be very embarrassing when you are sitting there and your client is completely opposing everything that you are saying, which is what happened to the other representative in the proceeding today. So it just got me thinking, I don't think that's ever happened to me personally, but I'm sure it's happened to many of you, and I just want to encourage you to really put some thought and preparation behind becoming aligned with your clients. Last but not least, the 10th way that I think we can all work towards keeping things a little bit more pretty during our advocacy work would be to not get too emotionally involved. What I mean by that is this. We are kind of like knights for our clients. We are there to do battle for them, to fight for their interests, to help them, to save the day. And this process can be very intense and it can be very stressful for clients because, we deal with this all the time, but for them, this might be the most important thing that's happening to them. This might be one of the most stressful things that they're dealing with. And so it's very emotional for them, and it's very easy to become, we become close to our clients, we care about them, we want to help them, and we want them to feel supported. So it's really easy to be like, yeah, that guy is a bad guy, and to kind of side with them and say bad things about the opposing party. But we do need to remember that we have a job to do, and that at the end of the day, what's going to win the day is not how passionate you are for your client. It's whether or not the facts can be supported by evidence, whether or not we are aligned with the laws and the rules. We need to be supportive and caring and empathetic while also being grounded, measured, and technical in how we proceed. And sometimes that can be really challenging to do. It's not easy taking on the burdens and the battles of other people. Our job is very challenging. And, the other thing too is that, kind of back to what I was talking about in terms of being aligned with your client and also preparing them for how to behave. It can be tricky if you have a difficult client. Like if your client has a strong personality and they're really set in their ways, you can't change a person, right? But you can coach them, you can prepare them, you can you can teach somebody and sort of practice it out with them, right? But you can't, at the end of the day, you can't change somebody. And if they're going to get all worked up, and if they're going to be emotional or mean-spirited or act in bad faith, you really don't have control over how your clients behave. But you and I, we need to be the anchor for those emotions. We need to be sensitive to our clients while also helping them, gently and kindly helping them to understand that we really need to focus on, like, while we acknowledge that what they are experiencing is very difficult or painful or costly, we do need to stay focused, and we do need to make sure that what we're doing is in line with the rules, and that we're working within the law and the standards and rules of civil procedure, generally speaking. So sometimes it's hard to do, right, with clients who are very emotional, and it's really contagious. It's like it can affect us, right? We can get emotionally invested, but we need to remember to stay grounded so that we're looking at things objectively and staying cool-headed and clear-headed. And I guess that's really it for now. These are just some things that I thought of today because I was dealing with literally all of these issues today in my various matters. And anyway, it has been a long day of court work and I'm tired. So this pretty paralegal is about to take a little break. But advocacy doesn't have to be ugly, even though it sometimes is. But we can each do our part to help keep things a little bit pretty. Let me know if you have any other ideas about what we can do to keep things pretty with each other and with our clients. I want to hear from you. Thanks for listening.